My name is Henry Pitman. I'm a neutral at JAMS. I do mediations, arbitrations, neutral evaluations, and I've also served as a special master. Well, I was a magistrate judge in the Southern District of New York for 23 years. I retired at the end of September in 2019, and I thought my experience as a magistrate judge, during which I did a lot of settlement conferences, bench trials, other factual hearings, I thought that would be a good segue to doing neutral evaluations at JAMS. The principal aspect of my mediation style is trying to get the parties to think about aspects of the case that perhaps they hadn't thought about prior to the mediation, to think about the practical difficulties of going forward with a litigation or arbitration, and trying to persuade the parties that settlement has great advantages, principally cost control, certainty of the outcome, and control of the outcome. I think the hallmarks of a successful arbitration are an arbitration in which both sides feel like they've been heard, that their arguments have been understood, and that they've gotten a fair shake. When I was in practice, there were judges that I appeared before. I didn't always win, but there were a number of judges who always left me with the feeling, even when I lost, my arguments had been heard, been understood, and had been rejected for a valid reason. And that's a practice that I tried to emulate when I was on the bench, and I try to emulate it now in arbitrations. Practicing in a great commercial city like New York, there are so many contract disputes. You can't practice law without getting involved in contract disputes. It's an area that I feel I have a good grasp on, both in terms of common law contracts that are governed by the Uniform Commercial Code. I had a number of employment actions when I was on the bench, both for settlement, for dispositive motions, for trial. I also have an interest in aviation cases, which is just sort of an offshoot of my interest in aviation in general. I think my background on the bench was excellent training to conduct neutral evaluations, whether it was a bail decision, whether it was looking at a summary judgment motion or a discovery dispute, or writing a decision after a bench trial. Everything I did involved looking at the facts, hearing both sides, considering the legal arguments, and ultimately deciding who had the stronger argument on the particular issue, which is identical to what I do in a neutral evaluation. But one of the aspects of my background, which I think helps me to be an effective neutral, is the wide range of subject matters I've been involved in on the federal bench. I've been involved in everything from securities, antitrust, intellectual property, all kinds of commercial disputes. And I think that wide range of experience and the ability to master the subject matters sufficiently to address the case or to deal with the case is a skill that I hope serves JAMS clients well.